Thanks for coming. We're going to get started. We're doing a Zoom as well. So my name is Greg Downey. I'm a course director in digital marketing. I teach law courses. What I don't have a lot of time to spend time on, which I would love to, is the First Amendment of the Constitution, which is really important to all of us. Doesn't matter what program you're in or what you're studying and want to become. The First Amendment is important to all of it. So Larry Walters has agreed to talk to us about the First Amendment and dedicate, and I can't dedicate much more than 5 minutes in some of my courses to the First Amendment. It usually revolves around spam, whether or not spam is violative of the First Amendment, which it's not. And Larry could talk a little bit more about that. And I also talk about defamation. So I know that you have that in your presentation. What is the way I teach it is because it's a digital marketing program. It really has to do with bloggers and anonymous bloggers and what courts do to reveal an anonymous blogger. It's so easy to get away with defamation if no one knows who you are. Yep. It seems like all the worst things come from someone who's anonymous. You hide behind that.
Keyboard warriors.
Yeah, right. So Larry is an expert in the First Amendment. He has tried cases in front of the United States Supreme Court. He's going to take us through the First Amendment, but specifically, which I think would be interesting to full sailors, is how the First Amendment relates to gaming and gambling, which is, I think everyone's interested in those two topics as full sailors. So he's got a lot to go through, so I'm going to shut up and Larry, take it away.
Greg, really appreciate that introduction. Thank you all for attending and welcome to our presentation on the First Amendment, gaming and gambling. Entitled "The Games People Play." There are a lot of games out there. Welcome everybody on Zoom. Appreciate you listening in. I have kind of a unique practice. I'm located here in Central Florida in Longwood, but represent clients all over the world and throughout the nation, primarily on First Amendment and gaming and gambling issues. So this is a perfect presentation for me. There are a number of intersections of how the First Amendment and freedom of speech in the United States plays into the world of gaming and gambling. And we're going to kind of go through some of that and see how the First Amendment allows some of these unique business models to exist and protects them in certain ways and allows companies to advertise gamified shopping and sweepstakes and various other business models. I'm assuming that we've got some gamers in the audience, maybe some gamblers, perhaps some of you play online and either in sweepstakes or offshore casinos or maybe some licensed casinos. Florida is getting more and more expansive in gaming and gambling. We have a compact with the Seminole tribe to allow sports betting, tied up in the courts right now, but sooner or later we're going to see gambling expansion in every state. It's coming slow but sure. And so I'm going to talk to you a little bit about how this all plays together, and want to give you some background on the gaming issues and the First Amendment by giving you a little story about how we got to where we are on the issue of online gambling. And so, back in probably the late 1990s, early 2000s, online gambling was the Wild West. There was basically no regulation. The government didn't know what to do with it. There were no state laws or federal laws prohibiting online gambling. And so you had these sites popping up all throughout the world, including in the United States, offering the ability to play gambling games online. And so oftentimes the operations would get a license in a jurisdiction like Curacao or the Isle of Man or Barbados, and get an actual online gambling license and then offer their services throughout the world. So they'd be licensed in their home jurisdiction and then have the entire world as an audience. And that went on for a while. The most important thing for those sites, those operations, was to get the US market, because we are the target market. We have the disposable income, lots of people that are interested in gaming and gambling. And so these website operators wanted to be able to advertise in the United States. That was the key, is to get the ads in front of people in the United States for them to be successful. Well, the government wasn't too sure about this. There wasn't a specific prohibition on online gambling, but there was a very unique Supreme Court case on the First Amendment and advertising that played into this. Basically, the case, it's called New Orleans Broadcasting Association versus Greater New Orleans. And it said that gambling advertising is legal so long as the gambling is legal in the place of origin, even if the advertising of the services would be illegal in the place where the gambling ads were received. And so the government had the ability to restrict illegal activities, but so long as the activities were legal where they were occurring, the fact that the ads might bleed over into some other territory, that did not render the advertising illegal, because advertising, as we'll talk about, is protected by the First Amendment. And so this was a key issue for online gambling sites to be able to get the ads to US customers. And you started seeing ads for offshore gambling sites all over network TV and magazines and newspapers in the United States. And we're talking about early 2000s here. I remember, sitting at home watching a show called Desperate Housewives at the time, and saw the first time an actual online gambling advertisement, network advertising, and it was right there in your face, and it was everywhere all of a sudden. Well, the Department of Justice didn't take kindly to that. They still treated gambling at that time as a vice activity and possibly infiltrated by organized crime. And so they want to try to get a handle on this advertising that was going on all over the United States. And so they sent out a letter, turned out to be a pretty controversial letter. The DOJ letter is about 2004, that basically put the industry on notice and said, if you advertise in the United States, we consider that to be aiding and abetting illegal activity because gambling is not legal in the United States. And so that shook up the industry for a while, and that forced the issue of, wait a minute, the ads are protected by the First Amendment because the gambling is legal where it's occurring. And there were some court cases and some battles, and the industry was pushing very hard to get these ads in front of people. Meanwhile, the states were considering their own prohibitions on online gambling. The federal government tried a few times, but failed because it's hard to get anything done in Washington, let alone a controversial thing like prohibiting online gambling. But then finally in 2006, they passed a law, it's called UIGEA. Kind of in the middle of the night, they snuck it into a bill, an anti-terrorism bill called the Safe Ports Act. That was like 500 pages. And in the middle of towards the end, it said, oh, and also online gambling is illegal. It was a little more complicated than that. Basically, it prohibited the acceptance of money for purposes of online gambling in the United States. And they did that intentionally because they weren't dealing then with the advertising of online gambling. They were dealing with the financial transactions of players trying to get money to the offshore gaming sites and the intermediary role that the banks played in that. And so as soon as you could cut off that flow of money to the offshore gambling sites by scaring the banks into saying, hey, this is now illegal here, the industry is essentially doomed. And that's kind of what happened. In 2006, online gambling, acceptance of money for online gambling was criminalized. Most of the websites pulled out of the United States out of fear of being prosecuted. There was a few of the large poker sites that stayed on, that continued to allow poker activity to United States individuals, US play, and that went on for a few years until something called Black Friday, which was an indictment of a number of online poker sites by the Department of Justice under the theory that they were violating US law. Previously, the poker site said, hey, we're not gambling. This is a game of skill, really. It's not a game of chance. And we'll talk a little bit about that distinction in a while and why that's important. But ultimately, they lost on that issue, at least from a practical standpoint, because the government seized all their money. They weren't able to do any business with US customers, and they essentially pulled out. And that led to all the rest of the online poker sites pulling out of the United States. For a while, they tried crypto after that, because you don't need a bank intermediary to send crypto. And so there were some crypto offshore gambling sites that were allowing US play. And those transactions went on for a while. The government prosecuted a few of the crypto operators. So there are a few of them left, a few underground. As you probably know, if you go online, you'll see the ability to place a bet on a football game or on casino gambling. All of that is largely illegal offshore operators that are operating in the shadows, using various ways to try to get money from the United States to the foreign operator. But now the states are starting to legalize online gambling intrastate, right? So that means that only players that are located in the state can bet, and then the operator has to be licensed. And we're seeing, maybe 20, 30 states that have some form of intrastate online gambling, which is specifically allowed by this law that was passed in 2006. But that's basically what happened, is that you had this effort to advertise to the United States players, which is considerably important, which the operators knew is the key to the market. The gambling activity was essentially shut down by the UIGEA, which passed in 2006. Black Friday hit, that was in 2011. April 15th, 2011, tax day. And that left the First Amendment issues kind of in limbo because the gambling ads are arguably still protected. For a while, they played a very unique game to try to get the ads to be accepted by the national news and the broadcast networks. The operators created .net free websites. And basically what that was is you could play for free, you could not win anything, but you could learn how to gamble, and you couldn't win any money. And the site was a derivative top-level domain .net instead of .com of whatever the popular name was. And they advertised only the .net sites, the free sites, under the theory that this is protected by the First Amendment. It is entertainment value. It's purely recreational. Some people figured out that, oh, if you go to the .com, you can actually place bets on that exact same site. It was an innovative way to try to use the First Amendment to continue getting the information to the United States players in an effort to then generate business for the .com site, since the .com could not be directly advertised. It kind of illustrates the interplay of the First Amendment and how that affects gambling and gambling advertising. And that's basically how I got involved in online gambling. I was a First Amendment lawyer by training. My website's firstamendment.com. For many years, I focused purely on First Amendment issues. But when this gambling advertising stuff started to come up in the late 1990s, early 2000s, it became a center point of our practice. And now we're involved in various forms of activity and representing clients that do things that are not really gambling, but kind of close to gambling. And so we'll talk about some of those business models and why they're legal and where the gray areas are. Just to kind of cover what I want to talk about, we're going to discuss how the First Amendment protects online gambling. What are the elements that you have to show to demonstrate that something is gambling? If you remove one of these elements from the equation, it's no longer gambling, and it's presumably protected entertainment and protected by the First Amendment and allowable in a free country. And so we'll talk about how the protection of advertising impacts the ability to advertise where gambling might be illegal itself, and the legality of some of these cutting edge business models and some of the emerging issues that we're watching coming down the pipe in the future. All right, so I want to start with giving you a basic understanding of the First Amendment, what it protects, what it doesn't, because that'll become more important as we talk about the business models. So what speech is protected by the First Amendment? First of all, the First Amendment is commonly misunderstood, particularly at the university level. We see some studies that are pretty shocking in terms of what people think about the First Amendment and what it does and does not do. So, for example, 63% of students believe that hate speech should be punished by the government. We're going to talk a little bit about hate speech and what it is and what it isn't, but pretty shocking number that most students believe that it should be punished by the government. 45% of people surveyed in a recent study last year believe that you should be able to shut down another speaker or prevent somebody else from speaking if the audience believes that the speech is hateful. 44% think it's appropriate to shut down a campus speaker, as mentioned, and 48% believe that some speech can be so sensitive that it deserves the death penalty, from a Yale study, believe it or not. So that kind of illustrates the hostility that we're seeing at particularly the university level to the First Amendment and the misunderstanding of how protective the First Amendment actually is. So let's talk about the starting premise. We all start from the position that all speech is protected by the First Amendment.
Hey, Larry, real quick.
Yep.
While you went back, because you and I dealt with this the last time that you and I, it's intuitive, but
right.
a lot of people don't know, the difference is this is a private university. Full Sail is a private university. So the difference between the way Full Sail might be able to treat speakers and the way a public university might be able to treat speakers. And
that's an excellent point. And so the First Amendment only prohibits the government from censoring speech. It does not impact private parties. And so if you have, for example, a private university, they can have more restrictive rules and restrictions than a public university, which is funded by the government, operated by the government, and has to comply with the First Amendment. This comes up all the time in our practice in connection with people that believe they're being censored on social media. And so they'll say, my First Amendment rights have been infringed because Facebook shut down my account, or they won't let me advertise something, or they kicked me out of a group, or they did something to me on social media that feels like censorship. And the response is, frankly, that's not a First Amendment violation. These are private companies. They're not bound to comply with the First Amendment. They're not restricted by what the government has to do. The government can't censor your speech. Social media can, and they often do. And there's a special protection that they have, something called Section 230, that allows them to censor and take action against users without any liability for their actions. But in any event, in terms of what the government can and can't do, all speech is presumed to be protected. The Supreme Court has created these so-called carve-outs or exceptions for certain types of speech that have historically been deemed to not be protected by the First Amendment, or not considered worthy of constitutional protection. A good example is child pornography. The politically correct term now is CSAM, underage content depicting sexual activities. That is not protected by the First Amendment. The idea there is that the individual who was filmed is being re-victimized every time the content is viewed or distributed in any way. And so therefore the government has a sufficient interest in prohibiting that re-victimization. Is essentially a crime every time somebody views it or distributes that type of content. So it's not going to be considered protected by the First Amendment. But the line is there that it has to depict an actual minor. The government tried to go further and prohibit content that depicts young-looking individuals, or something called a parent CSAM, a parent child pornography, young-looking individuals engaged in sexual activity. And the Supreme Court said, no, that goes too far, because our justification in the first place for allowing you to censor CSAM is that an actual child is being victimized. Here, everybody is an adult. There's no actual child victim. And so therefore that law is unconstitutional. I throw in these case citations in the slide in case anybody wants to look them up or doesn't believe they're real or whatever, but the slide does have the case citations to what I'm telling you about the First Amendment. All right, so we saw these statistics about hate speech and how it should be punished, and some people even believe it's appropriate for the death penalty. Is hate speech protected by the First Amendment? So important to know is that there is no definition of hate speech in the law. It's not a thing. Speech that people hate is often referred to as hate speech. There is no objective test to determine whether something is or is not hate speech. It's often used in the context of racially divisive speech or offensive speech to a particular group or religion or minority or culture. But the reality is, under Supreme Court precedent, that offensive, indecent, and even vile speech is fully protected by the First Amendment. That has been reinforced as recently as last year in a case called Mattel versus Tam involving trademark issues. Yes, please go ahead.
Yeah. Oh, I don't know if you'll cover this, but what about like death threats or things like that?
Death threats, excellent. Yes, we will cover that. We're getting to death threats. First, we're talking about hate speech, and here we're talking about something that offends somebody's sensibilities. We live in the United States, and we're all expected to have a reasonably thick skin because we live in a country that honors free speech. And the remedy for bad speech, we believe, is more speech, not censorship. And ultimately, the marketplace of ideas will decide what is the best speech, what is truth. And the way that you will reach that truth and reach that determination is by allowing all voices to be heard. And the best speech and the most valuable ideas will rise to the top, not by censoring speech and prohibiting people from speaking. All right, so threats, very good. So are threats protected? Well, threats could certainly be a form of hate speech. The answer is no. Threats are not protected, but there's some very important criteria to determine whether or not the threat is one that's not protected by the Constitution. The threat must be directed to specific persons, one or more persons. It doesn't have to be a single person, but it has to be identifiable. You have to be the subject of the threat for the threat to not be protected by the Constitution. And the recipient must also believe that they will be seriously harmed by the speaker. So there's some nuances here. We see, social media posts, just general social media posts that are threatening, but are not directed at a particular person. That's going to still be protected by the Constitution. We see, rap lyrics, for example, F the police, something like that. That's maybe directed at a type of job or government actor, but is not specific in nature. And so that will continue to be protected by the First Amendment. But actual threats, identifiable threats, where you feel threatened with bodily harm or other sorts of harm is not going to be protected. And this is similar to something we refer to as fighting words. I'm going to kick your ass, something like that is deemed to be a threat and not protected by the First Amendment. You're using your words to initiate violence and therefore it's not protected. Yes, you got to follow up.
So I'm sorry. So you're saying when you say it's not protected, that means that
it can be criminalized.
Consequences.
Correct. Yes.
Okay.
And it can be prohibited by the government. Ordinarily, you cannot. The government cannot prohibit speech. Right. All speech is allowed. All speech is protected. We're talking about the exceptions here. So the government can pass a law saying you cannot threaten people, and we have those laws. There's assault laws and harassment laws that are specific like this. That an individual cannot be the subject of a threat or a harassment campaign, for example, in Florida. But there's always these gray areas in terms of, well, how specific was the harassment? How specific is the threat? And the Supreme Court is considering some of those cases in terms of social media because of the kind of inchoate nature of a social media post. If it's just put out there and it's not directed to a person, it's not tagged to a specific individual, but maybe that individual knows it's about them, that's where the nuances come in.
Taylor, real quick, we talked about this last time too, is what is speech. So just give us a little sense of like when someone's wearing a t-shirt. Remember there's that case where there was a guy in court with a t-shirt that said something about nasty thing about the police or whatever.
Yes, sir.
Speech, it's just a t-shirt, right?
It's not only a t-shirt. So Greg is asking about, what is speech? Is speech just speaking? No, it's much more than that. Speech is books, movies, video games, as we'll hear about, wearing a t-shirt that conveys a message, dance, even nude dancing has been found to be protected by the First Amendment. So speech comes in many forms. The courts struggle with distinguishing between speech and conduct. Conduct is not necessarily protected unless that conduct is designed to convey a message. So for example, in the nude dancing cases, the court found that erotic dance is designed to convey a message of eroticism, whereas people just being nude out in public, like in a nude beach, is not. That's just conduct. And so there always has to be some intent to convey a message. And so what Greg mentioned was the case involving Mr. Cohen, who decided to wear the F the draft shirt in court with the full word spelled out, and was punished, arrested, and ultimately the Supreme Court found, no, you cannot punish somebody for wearing a shirt like that because that's protected speech. We had a case involving a bumper sticker that used quite a lot of F words, F you effing F, and she was pulled over, our client, by a law enforcement officer that thought that that should not be protected speech, and issued a citation for obscenity. We'll talk a little bit about obscenity, but that case was dismissed because it was not obscene, and there's a difference between profanity and obscenity. Yes.
So when it comes to bullying, because you mentioned social media, and I think of maybe more of a bullying, especially when I think of younger folks. Well, maybe that's all ages. But does that fall under the threats when you have these bullying scenarios where the result is pretty horrific, but maybe not at the hands of somebody else, like physically at the hands of somebody?
Yes, so cyberbullying and bullying in school are areas where there's a lot of litigation about the scope of these laws, how broad they can be, how they can be applied. Certainly, there's a greater interest in protecting children from offensive conduct and harassment campaigns. So the government can get away with a bit more restrictions in the school scenario, for example, and with younger children. But when you start talking about adults, even adults in a university, bullying has to be very severe. It has to essentially amount to a threat in order for it to lose constitutional protection. All right, moving on. How about lies? Can you lie? Are lies protected by the Constitution? What do you think? No way. Anybody say yes? Yes, lies are protected by the United States Constitution. United States versus Alvarez, involving something called the Stolen Valor Act. He went around saying that he was a war hero and won a bunch of war medals and told everybody this. And there was actually a statute that said you can't do that. You can't claim to be a war hero unless you're a real war hero. That was declared unconstitutional, and the court found that the mere fact that somebody is lying does not remove the constitutional protection from the speech. There are exceptions, as you can imagine. So what about defamation? Defamation is a form of lying. It's a false statement of fact about another person that injures their reputation. That can be punished. It can't be restrained. So in other words, a court can't stop you from defaming somebody else. You cannot talk about this other person. You can't say bad things about this other person. That would be what's called a prior restraint on speech. But you can suffer consequences if you defame somebody. You can be sued. In some states, you can actually be prosecuted. But a defamation claim has to involve a false statement of fact about another person. If you're merely giving your opinion about somebody, this person sucks. Well, that's not able to be proved true or false, right? It's not a statement of fact. That's an opinion. Opinions are 100% protected, but false statements of fact, this person is a criminal convict, or this person went bankrupt. Those are facts. They're provable. Yes or no, it happened or it didn't. And if you get that wrong and somebody is injured in their reputation or their business, you can be punished for that. What about fraud or misrepresentation? You defraud somebody into a commercial transaction. You tell them the house is not haunted. No, I've never seen a ghost here. And you sell them a house and it turns out to be haunted. There are cases about that, actually. So you cannot lie in the course of a commercial transaction. Otherwise, you can be sued again for fraud or misrepresentation. So lies are protected speech, but liars can face consequences. What about pornography? Yes, protected speech, unless it's obscene. Now, this is an area we talk about all day. Very quickly, there's no such thing as pornography in the law. It doesn't recognize that term. All speech is presumed to be protected merely because it involves sexual activity, does not remove the protection from that type of speech. But the court has recognized that obscene materials have historically been prohibited in the United States, and therefore there is some line at which pornography can veer into obscenity. And there's a complicated test for what is obscene versus not obscene. It's called the Miller test, and it's kind of antiquated. You don't see many obscenity cases lately because of this. It's very hard to get juries to put somebody in prison for making a movie involving adults that other adults want to watch. But this was a very active area of prosecution for a while until about 2010, 2008, 2010. But there is a line at which pornography can veer into obscenity and be punished. Now, obscenity is different than obscenities or profanity. As we talked about, profanity is constitutionally protected. That's not the same thing as obscenity, which is this narrow subset of pornography that fails the Miller test and is not tolerated by the community and lacks any serious value. All right, what about video games? Focusing more on what you all do here. Are video games protected? What do you think? Logically, should be, right? No different than books or movies, and that's ultimately what the courts held. There are a number of states that were trying to impose age verification and labeling obligations and ratings on video games because they were too violent. And the theory was they stirred up teen angst, and they resulted in aggressive behavior, antisocial behavior by young people. And so we can require people to show ID, prove that they're over 18 before they can get access to certain video games, or they must be labeled or stamped in a certain way. The court said, no, video games are no different than books or magazines. No reason to treat them any differently merely because they involve some interaction, merely because you can change the outcome of the story by participating does not mean that they lose their constitutional protection. So interestingly, depictions of violence in the United States are not a basis on which to deny constitutional protection. So we treat sex and violence a little differently. There is a point at which sexually oriented material can become illegal, but violence, have at it. You can show whatever you want and it does not lose constitutional protection. So at the end of the day, the court said you can't impose labeling obligations or ratings or age requirements on video games because they're the same as books and movies, and they're fully protected by the United States Constitution. Good to know for any of you who decide to make video games. There was a time in which there was a very strong push to try to impose restrictions on video games based on their content. All right, what about gambling? Gambling protected speech. This is where it gets complicated, right? Because gambling is a form of commercial transaction in addition to some media occurring alongside the commercial transaction. So you have animated spinning wheels, or you have dice rolling, or sometimes you have very active graphics in modern gambling machines. That is a form of video. It's a form of video game, right? That we already heard is protected. But you also have paying money and an opportunity to get more money back if the animation shows that you're a winner. So you have both speech and conduct occurring at the same time. And that's kind of the line that the courts have drawn, that the gambling transaction can be regulated and can be prohibited and can be subject to age requirements and a lot of other things. But the surrounding media, the games occurring in the background, are protected, constitutionally protected as speech. But the United States does impose very heavy restrictions on gambling on a state-by-state basis. And if the gambling is interstate, it's going across state lines, then the feds can get involved and the federal government can regulate the interstate gambling components. So that leads us to what is gambling? What do you have to show, or what business elements does there need to be for gambling to occur, or for some activity to be considered gambling? All right, 3 elements, very important: prize, chance, and consideration. There has to be some prize of value. We'll talk about what that means. There has to be a chance of winning something and also a risk of losing something. That becomes important. And consideration, money or something else being paid for the opportunity to win a prize by chance. That consideration doesn't necessarily have to be money. It can even be personal information or effort, time and effort, filling out surveys or providing information about yourself. That can be considered consideration for purposes of gambling. And that comes up in some of the sweepstakes cases that we'll talk about. All right, so delving in a little more on the prize issue, we'll talk about prize, chance, and consideration, and then we'll talk about some business models that use these and try to eliminate one of those elements so they're not considered gambling. All right, the prize needs to be a real world thing of value. So that means the prizes that you get in video games, gold coins, oftentimes, good loot or skin, weapons, etc. The courts have generally said these virtual in-game prizes are not real world things of value. They are only used in the game. They don't have any tradable value. They don't have any actual value in the real world. And so long as that prize is the type that's awarded, we're not talking about gambling. There is one exception in Washington. Washington has some pretty crazy strict gambling laws. It's actually a crime to even place a bet on an online game in Washington. And so it's not surprising that the court cases there go a little different. The courts there have said even in-game virtual prizes can be a prize of value for purposes of gambling, particularly if there's a secondary market, if you can trade those virtual prizes with other people, and if that virtual prize offers the opportunity to extend the game. The right of replay is what they call it. That will result in the prize being considered real world enough. Yes?
And so that's only from the game to the person, right? Because I know that there's times where you can pay like real money in a game to get a certain price or skin or whatever it is that to play the game, you can actually like pay for it.
Exactly right. Exactly right. So, what you're talking about there is you have consideration, you're paying money, and maybe there's a chance, maybe, that prize you're talking about, the virtual item is awarded by chance, but the prize is not considered to be a prize of value. So you remove the prize from the calculation, and you no longer have gambling, except in Washington.
So that would make it like supported.
Means that's not gambling, and so it's legal.
Oh.
And so what we're really talking about is it's protected by the Constitution, because if it's an entertainment, if it's type of media that's providing entertainment, it's presumed to be protected by the Constitution, presumed to be protected by the First Amendment, so long as it's not gambling. But if we have prize, chance, and consideration mixed in there, that's where it veers over into something that can be criminalized, very serious criminal penalties. All right, chance. What about chance? This is a tricky one too. The winner must be determined by chance. How much chance? There's a lot of games that involve both chance and skill, right? So, poker is a really good example. Good poker players tend to win most of the tournaments, but you're subject to the chance roll of the cards. You can't control which cards come up. And ultimately, the courts that have considered it have determined poker to be gambling and a game of chance, because primarily chance plays the dominant role. But there's these different tests that the courts use in different states. Dominant factor tests, does chance or skill dominate over the other? A material element, does chance play a material or substantial or meaningful role in determining the outcome? The any chance test, which is the strictest one, is the outcome determined in any way by chance? And that would render most games of skill a gambling operation. Florida is one of the most complicated places on this issue. They haven't settled on a test yet. They use this old test to determine whether or not chance is inherent in the machine. And what they're talking about there is gambling machines, which really have no applicability to the internet. And every computer is potentially a gambling machine, because they can conduct gambling calculations. They can award prizes by chance. Is my phone a gambling machine in Florida? Probably. But we don't really have any determinations on that. It's not been clarified. And that's where these issues become complicated when you're talking about skill gaming. That's one of the business models we'll talk about in a minute. But generally, if chance is a significant factor in determining the outcome, then you have chance as the element, and gambling can occur. Consideration is the final one. There needs to be something of value that's staked on the outcome of the game, and the player must be at risk of losing that bet. And so the payment must be for the gambling transaction and not something else. So for example, we'll talk about sweepstakes. People are paying for a prize, they're paying for a product or service, and they have an opportunity to separately win a game of chance. They're not paying for the chance, they're paying for the prize, they're paying for the product or service. So you think about like the McDonald's Monopoly game, where you go and you buy a hamburger and you get a free ticket to win a drink or maybe some money. You're not buying the ticket, you're buying the hamburger. And so here, consideration must be for the bet. If you could walk into McDonald's and pay money for that prize ticket, that would be consideration. You're paying for something else, like food or some other product or service, that's not consideration.
Just real quick, can you discuss, it may be in here, I can't remember, the difference between the law, because we were focused on the law, but then there are like rules, right? So I think about in the context of Full Sail, I don't know what the rule is with respect to this, I'm making it up, but if I were to create a fantasy football league, whoever wins that fantasy football league wins $100 a pot, right? So we all put $1 in at the end of the season, I win, my fantasy football team wins, I get everyone else's money.
Yep.
Gary comes to me and says, you're fired, right?
Right.
So, and I can say, no, it's not against the law.
Yeah.
It's a game of chance. I'm allowed to do this. But he says it's against our rules at Full Sail. I'm making all this up, by the way. But I'm thinking about actually doing it now.
Yeah.
But so there's difference. And you and I talked about this last time regarding school uniforms and, that getting back to the idea that it's not just speech, it could be something you wear.
Right.
And the school kicks you out because you're wearing something that was inappropriate. That from a legal perspective, it's different than from a rules perspective. If school can, and then what if I get fired and I file a wrongful termination suit saying what I did was legal? You can't fire me. Well, Florida's a state. So how does all that stuff interact? Because there's just differences between laws and rules.
There is, and what we're talking about here are government laws. What can and can't the government do with regard to speech and gaming and gambling? If you work for an employer, they can impose all kinds of rules and contractual obligations on you that have nothing to do with what the law does or does not prohibit. You can agree to be bound by a contract or bound by the school rules in exchange for your benefit of having a job here. And that's essentially what happens. So if you take a job somewhere, they give you a handbook and said, these are our rules. And this is not the law of Florida, it's just the rules that we have created in order for you to have the job here. And so you can lose your job if you don't follow the rules, even if everything you did was completely legal. Right. So that's the point there. And then of course, there's things that are like policies that aren't really written down and they're just followed and everybody knows them. And then that gets into a lot of litigation in courts as to, well, I didn't know this was a formal policy. It wasn't written down anywhere. I wasn't put on notice. So that's the least formal type of obligation is a policy or custom. But in terms of rules, yes, your employer can impose rules. And there's different levels of laws. There can be rules imposed by cities that have nothing to do with state law. The cities can make more laws and criminalize more activity or prohibit more activity than the state can. And we'll talk about that when it comes to simulated gambling a little bit. But we talked about the elements of chance, skill, and consideration. Well, what about skill gaming? Talk about some of the business models here. There's a lot of skill gaming out there, a lot of games you can play online where chance is not the determinative factor. Instead, it's the skill of the player. Skills is a big platform out there that a lot of people use, that you go head-to-head matchups with other people and you play games of skill, chess, something like that. Arguably, that eliminates the first element we're talking about, chance. If there's no chance, then the game is legal. Can't be prohibited by the government unless the government decides to pass a specific law banning wagering on skill games. It's not considered gambling, but the government can say, we don't like skill gaming. We don't like wagering on games of skill. And that's what Florida has done in about 10 other states. They've passed laws that say you cannot wager on games of skill in addition to games of chance. But Florida courts struggle with this because they want to still allow people to go to the fair, midways, and throw a dart at a balloon, or allow a golf tournament where people pay an entry fee and they might win a $500 prize. And so the courts try to make these exceptions, and they draw these kind of very illogical distinctions between playing a game of chance and participating in a contest of skill that requires an entry fee. And that's where the gray area is. But the bottom line here is that skill gaming is not gambling. If you eliminate the elements of chance, then it's not gambling anymore. It's a skill game, and skill games are very popular, unregulated in about 40 of the 50 states in the United States, and very popular these days. What about these mystery box business models? Have you heard of this? Where you're buying something, but you don't know what you're going to get. That's become very popular online. And you're talking about here eliminating the risk of loss. Remember, we talked about consideration. You're paying something, but you also have to have the risk of losing something. Here, there is a prize. It's determined by chance, and you're paying something, but there's no risk of loss because you're always going to get what you paid for. You might not know what it is, but it's always going to be worth the value of what you paid. And that's the key to the legality of a business model like this, is whatever you pay, you have to get something in return that is worth that much. And usually it's physical items. It's a variety of physical items, a collection of electronics for Apple or something. But more often now we're seeing mystery box business models that allow virtual prizes or experience points that have some value. And that's where the open questions are. That's where the gray area is. But the idea is, as long as there's no risk of loss, the game is not gambling because you're getting the value of what you paid for, even if the prize might be determined by chance. Social casinos. Anybody play social casinos where you pay money and you don't win any actual prizes? It's a multi-billion-dollar industry. A lot of people play, and don't ask me why, but it fills a lot of people's time. And a lot of it is about bragging rights and socialization. And I'm better at this than you are, and the forums where you can talk and show how experienced you are. You get to different levels, and there you've got chance and consideration, but no prize because all the prizes are virtual. Yes.
Wait, so they pay real money and don't get anything back, or is it fake money on that?
In social casinos, the idea is no actual prizes. You can pay money to get tokens, you can wager them, you can play casino games, you can play poker, baccarat, whatever you want, but the prizes you get are all virtual. It's just numbers. You can sometimes get different awards or trophies or higher levels. So long as there's no real world value to the prize, this is not gambling because you've eliminated the element of the prize. There's a mixture of social casinos with sweepstakes that I'm going to talk about towards the end, which is where a lot of the action is right now. So sweepstakes, the general idea is, yes, there's a prize, yes, there's chance, but there's no consideration. So as we're talking about the McDonald's example, you pay for a product or service, and in accordance with your purchases of those products or services, you might get an opportunity to win a prize. We saw a lot of this in the internet cafes that were all over Florida a few years ago. There's been a pretty significant crackdown on them for various reasons. But the way they operated was that they sold long distance phone time, right? So you can go in there and buy X number of minutes of long distance phone time. And in accordance with those purchases, you get a chance to sit down on our machine and play something that feels a lot like a slot machine. And you can win real prizes. All you're paying for is the phone time. You're not paying for the opportunity to play the games. That's free, but you could walk away with some money. Now, oddly enough, people didn't use much of the phone time, probably because more and more long distance was included in people's cell phone plans. And that's where the legitimacy of the products and services comes in. If you're going to run a sweepstakes, the primary reason that the people are coming into your store needs to be to buy what you're selling, not to play the games. So, people go to McDonald's to buy hamburgers, not to go play the Monopoly game. With the internet cafes, arguably people were going there for the reason of playing the games, and they didn't care about the long distance phone time, because the government was ultimately able to show that people weren't using the minutes. But you can operate a lawful sweepstakes so long as you are only charging for products and services, and you're giving away free chances to play games of chance. There does need to be some market value to the products and services, and you have to have another way of entering into that chance game. So there has to be what's called an alternative means of entry. You have to be able to walk up and say, I want 100 free chances. I don't want to spend any money here. Same thing at McDonald's. I don't want to buy any food, but I still want a Monopoly ticket. They have to give it to you. Usually this is done by entering in, by sending a postcard or filling out a form. The gray area is, what if they ask you to write a review or follow or like their social media? Are you doing something that benefits them? Is there some monetary benefit flowing to them? That's where the open questions are. Raffles. All right, about this one. We have prize, chance, and consideration, because usually you got to pay money to get into a raffle, right? All right, so how do you get away with running a raffle? Get to ask that question quite a bit. I want to set up an online raffle. I want to give away a house and charge everybody $1 to enter. Sounds like a good business model. Problem is that raffles are only legal based on state laws, and the state laws typically require that raffles can only be run by charitable or civic organizations. And you can ask for a donation to enter into a raffle, but you can't require that somebody pay money. So raffles are restricted to charitable and civic organizations, and you have to be able to get a raffle chance for free. In Florida, they do allow you to suggest a minimum donation. So you can say, minimum expected donation for this raffle ticket is $5 or $1. But you have to you have to give it away. If you're the raffle operator, you have to give the chance away if requested by the participant. But this is another very close call because you have prize chance and it seems like consideration, but as a creature of statute, they're allowed so long as it's for a charitable or civic purpose. So we see another business model, these fantasy stock markets, where people are running what would seem like a stock market. You're not buying any actual stocks. You're just trying to outperform other people. You're running a contest, trying to see who's the better investor and who can pick stocks in a better way, or maybe even crypto, and compete for prizes in order to determine who the better investor is. Well, here we definitely have prizes. We have consideration. People are paying to enter, but chance, probably not, because the outcome is determined more by the knowledge of the person who is investing as opposed to mere chance. It's arguable, the stock market can be a wild ride and it can seem like it's a casino sometimes, but the better investors, more knowledgeable investors do better than those who are uneducated. The issue why you don't see many of these online is that activity is highly regulated by the SEC and the commodities boards. So you have to first go to them and get their permission to be able to operate something like that. And the only one that we're aware of that's been approved was one that was operated by a university for educational purposes to show people how to invest, but not for profit. Sports betting, and some of you interested in that, you definitely have prize and consideration, but really isn't chance, because the people who know more about sports tend to do better in sports betting, right? So why is that prohibited? Well, a couple of reasons. Mainly the Wire Wager Act, which is a federal law that prohibits the transmission of any betting information related to sports contests or actual bets across state lines using the wires. That would include the internet or telephones. It was passed in the 60s to try to deal with bookies who were placing bets on sporting events without authorization. So there's a federal law that prohibits this specific activity, even though it arguably doesn't involve chance. In the past, for a good portion of the last century, Nevada was the only jurisdiction that allows sports betting because they happened to be the one that was offering it at the time. A law was passed called PASPA, P-A-S-P-A, Professional Athletics Sporting something. And basically it said, well, if you're offering the activity now, then you can keep doing it, but otherwise it's going to be illegal henceforward. And that law was the law for quite some time. Nevada had a lock on it, and people were flying from all over the country to be able to place legal sports bets in Nevada. And ultimately that law was struck down in 2018 as violation of the Commerce Clause, basically saying the federal government can't tell the states what to do. This is a state activity, and if it occurs within the state and we're not using interstate wires, you have no business telling us what to do. And so that opened up the sports betting world for the states. And now you're seeing many states pass individual intrastate sports betting statutes, allowing the state to run sports betting operations or to license sports betting operations. But the key there is that it has to be intrastate. So these bets can only be taken by people who are physically located in the state, and the operator also has to be located in the state. So otherwise you'd be violating the Wire Wager Act because you're allowing the information to go across state lines. Florida, they actually passed a law, not a law, but a compact with the Seminole tribe that allowed for sports betting and took the position that you could even offer it on mobile phones and mobile devices, so long as the server was on the Seminole tribe property. That argument hasn't gone very far throughout the rest of the country when tried, but Governor DeSantis signed a compact that allowed it. Very quickly challenged by other gaming interests in the state of Florida, who didn't like the idea that all of a sudden the Seminoles got a very wide expansion of gambling activity, and the sports betting rollout has been stopped in Florida by the courts, basically saying that the compact is illegal, and this idea that you can offer it anywhere just because the server is on tribal lands is not sufficient. So we'll see what happens with that. If the court allows it, then it may be allowed only on tribal lands, where you'd have to go to a Hard Rock casino offered by the Seminoles, or if the whole compact is upheld, you may be able to get it on your mobile phone in the near future. Yes.
So if I understand that correctly, the compact
in Florida only allows for sports betting in the Seminole land.
And it's federal land, right? That's just,
Yes, that is true, sort of. So the compact that was signed ultimately allowed the Seminoles to run sports betting, only the Seminoles.
But so if you were here,
Mhm.
we could not, you'd have to be on the reservation.
Right, so the compact actually went further than that. That would be the typical way it's done throughout the country. If you're gonna give the gaming activity to a tribal land. But the compact said, so long as the server that is conducting the sports betting bets and that is processing the information is located on tribal lands, that anybody can connect to it with their cell phone or their computer, and anybody can place the bets from anywhere they want. That has, like I said, not held water in most of the country. And the Seminoles actually rolled it out for about a week or so until it was stopped by the courts. So we have to see how much of it is upheld. We might see a situation where you have to go to a Seminole casino to place bets, but if the whole compact is upheld, ultimately, you'd be able to place bets from your mobile phone. Yes.
I mean, I kind of know the difference, but what makes Florida allow an app like, you know, what Price Picks is? They have like a sports betting app where you can bet players to get a certain amount of points. It's like a normal gambling site, but they don't allow FanDuel. It's just weird that they allow some, but not others.
I'm not familiar with the particular site. We can talk about FanDuel and we'll talk about some of the sweepstakes business models that do incorporate something like that. You know, I'd have to see exactly what they're trying to do. But fantasy sports is one we're going to get to right now. I think it's the next slide. But sports betting is happening at the state levels, and we're starting to see more and more states roll out intrastate sports betting. So fantasy sports, why is that legal? The main reason is that, remember I told you about the UIGEA, which is this federal law was passed in 2006. It had an exception built into it for fantasy sports. And so basically said, if you're running an operation that allows people to create their own fantasy sports teams and bet on that's a popular pastime. We get it, we understand, and you can do that. You can even do it intrastate and interstate throughout the country. And here, you know, you have prize and consideration. The argument is that it's not really determined by chance, that the winner is not determined by chance because it's based on the knowledge of people's of sports and the performance of the players and how well they might do on their own if they were not a member of their existing sports team, but of a fantasy sports team that's made up of a bunch of different players. There are some particular restrictions. You can't determine the outcome based on the winning or losing of a single performance of a single game or a single athlete's performance. So, you know, it can't be sports betting to qualify as fantasy sports. It generally has to be the statistical accumulation of points by a particular player over a season. But now we're seeing daily fantasy sports where, you know, FanDuel and DraftKings, you can bet on a daily basis as to players' performance. And that is, you know, it's in more of a gray area. Bottom line with fantasy sports is it's allowed, and about half the states don't regulate it at all. So it's presumably permitted. Another quarter of the states license it. So you have to get a license in order to offer the activity, and another quarter prohibit it outright. In Florida, they've tried to pass a few laws allowing it, but they haven't gone anywhere yet.
Larry, one on the subject of Florida jurisdiction, federal land versus state land, state law, federal law. I guess I knew this was a thing, but I found out about it through my son. There are cruise ships that are all about gambling, right? So that they get into international water. Laws of the state don't apply anymore. They gamble, they come back. But the companies themselves are Florida companies.
Mm-hmm.
So I'm assuming that's a thing. You can't, the state of Florida can't stop those ships from doing that.
Yeah, it's a complicated issue of maritime law where basically the laws of the United States do not extend into international waters, nor do the laws of the individual states. And so there's various different measures as to what laws apply and how far out you have to go. But the idea behind a cruise to nowhere is that you can't gamble when you're docked, and you can't gamble when you're within a certain barrier, certain radius of the United States, But when you get into actual international waters, the laws don't apply anymore. And you can open up that casino and start taking bets. And that happens quite frequently.
And that has to do with the laws related to age too, right? So like you can't go into a casino in Orlando when you're 16.
Right.
But you could go on a cruise ship at you're 16. As soon as you get breach international waters, the 16-year-old can now gamble.
That's true. That's very true. And there you're talking about just the policies of the captain and the owner of the ship, right? They make their own rules as to what you can and can't do in international waters. Some of them allow younger people to drink too. Same thing.
But the state of Florida can't go after the owners of the ship. Let's just say it's Carnival or whatever, but they're a United States-based company.
Right.
The state of Florida can't say you can't go out into international waters, gamble, and come back.
Yes, the state of Florida has limited jurisdiction over the company and can control the company's operations in the state of Florida. But once a vessel is in international water, maritime law takes over, and after a certain barrier, the United States law and individual state law no longer applies.
So I just gave these guys an idea I should have done.
Yeah, no, they're very difficult to make profitable in Florida. Is the real reason why you don't see more of them, but it was a big thing a while ago. Crypto wagering. I'll just cruise through some of these. I know we're wrapping up, and also want to ask or give you an opportunity for any questions. Cryptocurrency. Here the question is crypto a thing of value? Is it a prize or is it consideration? And for a while, that was the argument that was used. It's not backed by anything. It's just worth what people think it's worth. It's not fiat currency that has any particular value. So the argument was it's not a thing of value and it's not consideration. So you should be allowed to gamble with it. And people did it for a while. There's no bank that has to control it. So player deposits could be accepted overseas. But over time, the courts have said, no, crypto now has a value. It has an actual market value that's tracked every minute of every day. And we're going to treat it as money for purposes of gambling. And the courts basically treat crypto however they want for the purpose that they want it. The IRS thinks it's property and they want to tax it as property. So they consider it to be property for purposes of gambling and money laundering. It's money. It's whatever the courts want it to be at any given time. But there's no difference between dollars and crypto at this point. So gambling advertising, we've covered a lot of this. Basically the advertising is protected speech, even if the gambling activity is illegal where the ad is being received. I think you've got that pretty clearly. Sometimes there's local prohibitions that come into play that are found to be constitutional. We had a case in Puerto Rico where Puerto Rico said you can advertise gambling to the tourists, but not to the locals. And that was challenged. And ultimately, the court said, well, yes, it's true that gambling advertising is protected speech, but if there's a significant enough governmental interest, and here it was protection of the locals so that we're not bankrupting the locals, it's okay to do it to the tourists, but not to the locals. Then we're going to uphold the law and we're going to find that that regulation does not violate the First Amendment. Here in Central Florida, we've had a couple of laws, ordinances actually, that prohibit simulated gambling. So something that feels and looks like gambling, but isn't really gambling. And there have been a number of legal challenges to that. Bottom line is that the cities and counties have a greater ability to restrict the activity than the state does, and they can prohibit things that are not prohibited by state law. And here, basically the court said, no, what the statutes and the ordinances are prohibiting is the conduct associated with these simulated gambling machines, not the actual media itself. And so the laws were upheld, the ordinances were upheld. Personally disagree with that particular ruling. I think it went the wrong way, but those prohibitions on simulated gambling machines have been upheld. Just to wrap up here, seeing some of the stuff we're watching, gambling in the metaverse, gambling that involves pieces of property in the metaverse that are all virtual, some of which are tokenized, that can be traded and sold, that do have some real world value, or like NFTs that have some value. That's where a lot of questions are. Is that going to be considered a thing of value or consideration for purposes of a bet? When the items are transferable between parties, like these skins are on the Steam platform or within any gaming platform, that tends to suggest that they are a thing of value. We're also seeing social casinos where, as I mentioned, you can't win anything, Well, what if a social casino and the purchases of the coins for the social casino allows you to then participate in a sweepstakes where you get free chances to be able to win real prizes on those very same games that you were playing where you could win no prizes. That's becoming a very popular business model, and theoretically, it should meet all the elements of a sweepstakes, should be legal just like a sweepstakes is legal, but hasn't been tested yet. The mystery box games where I mentioned, we're seeing more virtual prizes awarded as opposed to physical prizes. The question is, what is the value of those virtual prizes? If you're giving away like experience points to become higher level in the game, does that have a value? Is it worth what the customer is paying? If so, the activity is legal. And then in penny auctions, it's another popular business model where you're buying bid packs, you're paying a certain amount of money to then bid in pennies to try to win an item of a certain value. You might get an iPad and spend 50, 60 bucks. Is that gambling, or is that just an auction like anything else? So there's a lot of complicated issues there, very little case law on it. But the bottom line is that gambling is very popular, and that operators will try to find ways so that the activity does not meet three elements of prize, chance, and consideration. If one of those elements is missing and the state hasn't otherwise prohibited it, it's constitutionally protected, it's media like anything else, and it's a free country and you're allowed to engage in the activity. You guys have any questions?
I have a question about the taxes side of it. I know that's a little probably off, but when it comes to the winnings, on the flip side, whether you paid $1 or $60 or however much, but once you get something of the value, then you still have to pay the taxes on whatever that value was. I don't know, I think it's up beyond a certain amount. So I guess in these scenarios, is that a variable of the value perceived that's being treated or in there? Because at the end of the day, the government's going to get their money.
Government's going to get their money. Yeah, I will tell you, I'm not a tax lawyer. Don't give any tax advice. My general understanding is that you must declare your gambling winnings, and they're taxed at a very high rate. And you can only offset your gambling winnings by your gambling losses, not anything else. So yeah, the government will get their money, and you don't want to end up like Al Capone. Yes, sir.
So basically you can go into a casino, buy chips, and then gamble those chips. And that be like legal.
So yeah, what you're describing is the typical gambling scenario, right? Where you're buying the chip, that's consideration, you're paying money for the chip, and then you're betting it, and the outcome is determined by chance, and you have the opportunity to win a prize. That's clearly gambling. What we are seeing is this combination of social casinos and sweepstakes, where you start out with the social casino, you're buying, let's say, gold coins, and you have no opportunity to win any money. You're buying the coins, you're playing with the coins, but for every purchase of those coins, let's say you buy 1,000 coins, you get 5 free sweepstakes chips to play on those same games. You can't buy the sweepstakes chips, so there's no consideration. The sweepstakes is designed to encourage people to buy the gold coins. What's unusual about that business model is that the products and services that are being sold are identical to the sweepstakes games. And that's where the open question is, is it legal? It certainly meets all the definition of a sweepstakes. And it's becoming a popular way to essentially offer something that's similar to gambling without violating gambling laws. All right, well, I know we went a few minutes over. Really appreciate your attention during this time. And we don't have any other questions. Good, Greg?
Yes, we are good.
All right, really
Thanks,
appreciate
guys.
it. Thanks, guys.
I have to take.
Yeah,
this out.
Of like the very
Yeah,
first
just
one.
think.
Until, like, well, yeah,
I think.
next week, not, yeah.